Good morning, WTOB listeners. Welcome to For the Record with Greenwood Law. I am Dylan Greenwood, Managing Partner at Greenwood Law, here with Harold Eustache, Criminal Attorney at Greenwood Law, and we're here today to talk about the First Step Act. The First Step Act is actually a federal act and a state act, and while they share the same name, they do two entirely different things, don't they, Harold?
They do. One is pretty broad and one is very, very narrow.
Very narrow indeed.
Yeah.
And that's the state version of it. And we'll go through exactly what we mean by that and go through why the federal one is broad and brings a lot of welcome changes to the criminal justice system because there is a lot going on. A lot of what has brought this about and has made the First Step Act so important and prevalent in our society is because of jail and prison overcrowding. And it's interesting to note that the United States has somewhere in the neighborhood of 2.3 million people incarcerated, and even more than that at a given time. That is more than twice the amount that a country like China incarcerates its citizens, yet China has 4 times the population that the United States does. And it just really brings to light the overall culture and prevalence of incarcerating people that we have here in the United States.
Yes, that's right. And part of the issue that we have in incarceration, and part of the reason that this was even brought about, the First Step Act, was because of mandatory minimum sentences, which some people feel helped into have these racial disparities that we have in the criminal justice system. From what I've read, about 34% of inmates in BOP, which is the Bureau of Prisons, which is federal prison, are black. About 29% are white, and about 24% are Hispanic. So there's some disparity there in the type of people that are incarcerated.
Well, it really gets highlighted when you parse out the percentages of those different ethnicities within the United States overall population.
Right.
And it really highlights just the disparity that takes place in this.
Right.
And a lot of these upticks in prison populations happened following or around the 1980s.
Mm-hmm.
Well, Harold, what happened in the 1980s?
Well, the famous war on drugs that we had, and obviously there was a lot of crime in the 60s and 70s, and especially in the 70s, and in the 80s the whole drug selling stuff happened, and as a reaction to that, we had this war on drugs, and a lot of that, what came out of that was legislation which made mandatory minimum sentencing around drugs. And so now we're starting to look at that again and understand that some of those mandatory minimum sentences have really had adverse effects and have put people in jail for decades that simply just possess marijuana.
Yeah, so especially since there's a lack of data to back up these large mandatory minimum sentences really doing something to prevent recidivism, which is someone going and committing another
Mm-hmm.
crime again, whether it's the same crime or another crime. It doesn't really prevent that. And does it really penalize somebody? Well, it penalizes them in the sense that they're being taken out of society. They can't be a part of day-to-day life. But then the ancillary effects that happen from that, where you're being removed from the people you love for that long, you're being removed from society for that long, you're being institutionalized, it really contributes to these people going through a lot of issues that are far beyond just the fact that they are behind bars. Now, don't mistake what we're saying here. If you do something, you're guilty of a crime, there needs to be a punishment involved. That's a part of it. As a society, we have said that possession of drugs, selling of drugs, trafficking in drugs, or any other crime that has a mandatory minimum sentence, there deserves a punishment for that of some sort. It's just the disparity that occurs in these types of cases can be so far beyond what anybody would suspect. What's happened in the federal system that happened with the war on drugs to contribute to mandatory minimum sentences trickled down to the states.
Right.
And in the state of North Carolina, the highest levels of drug trafficking, the minimum sentence on that, and you could have never been in trouble in your whole entire life, but if you were convicted of the highest levels of drug trafficking, all of a sudden you're going to prison for approximately 18 years, 9 months. First time. It doesn't matter what your prior criminal history is, and that's at a minimum. It can go up from there. And if you're charged with more than one of these offenses, it's compulsory by the law is that all of a sudden those sentences are stacked on top of each other and cannot be run concurrent in any way.
Right.
And so it creates a lot of potential issues for prison overcrowding. It's already happened. Apparently, the United States is only about 104 to 105% quote unquote overcrowded. We're not the worst in the world. I think the worst goes to Haiti. They're like 400 and some percent.
Mm-hmm.
But still, it's a big issue and it's a big cost because of all the money that gets thrown at it. It is a big deal.
So, Dylan, with all these issues, how did the federal government respond to trying to tackle some of this?
So they responded in 2018. It was a bipartisan bill. It was signed by President Trump, and it was called the First Step Act. And the goal of the First Step Act was to tackle some of these issues head on. Throw some money at it, admittedly, change how we view certain things, how we're approaching certain things, to try and get people in a situation where we're reducing recidivism, we're balancing the need for society to institute a punishment for bad behavior, we're protecting people out there, but at the same time, we're trying to balance all this with the issue that we have with prison overcrowding. And so the goals of the act, first and foremost, was to reduce recidivism because we were seeing that just these long periods of incarceration didn't really do a lot to help with that.
There's some studies out there that show that long sentences don't necessarily reduce recidivism. It's
right, because when you're in prison, and if you're in prison for a long time, it's just more opportunity to meet other people, either doing something similar to what you were doing, or meeting new people that might get you involved in something else.
Right.
And what we have seen time and time again, Harold, I know you've seen it and I've seen it both, where you've got somebody that they get out of prison, it's difficult to find employment,
Yes.
they legitimately try, and then all of a sudden they basically give up and go down this other path that they've known.
Right.
And they fall back into a pattern.
I mean, I can think of numerous examples of that, or they're the same people that they were hanging out with, they just somehow get caught with one of those people, and that can lead to consequences. It's a rough thing.
Absolutely. And so the act not only addressed the recidivism issue, but it actually gave judges increased latitude in going below mandatory minimum sentences. So federal judges already had the ability to identify and take into account what we call 3553A factors. Those are these nature and characteristics of what occurred, what the person, their personal characteristics are, their history, their personal history was, and take that into account in imposing a sentence. Federal sentencing used to be this lockstep grid. If you fell into a certain criminal history category, if your sentence fell into a certain category, or your crime that you committed fell into a certain category, this was the sentence you automatically got. But there was a change in law there. It was analyzed by the courts where you could depart from that. And so this gives the judge to depart even from the mandatory minimums. It also increased the ability to have credit for good time served. That's been a really interesting sticking point in federal law specifically. The law in the books for the longest time was that you got 54 days of credit for every year that you served, as long as you had good behavior. So that works out to approximately you're serving about 85% of a
Right.
given sentence. But the way the law was written, or the way the law was interpreted from the way it was originally written, inmates really on average only received about 47 days of credit. So the First Step Act cleaned that language up to where it's a hard 54 days if you've got the good credit to apply and actually get it. And then also it increased the ability for inmates to transition into halfway houses and certain type of residential reentry programs to try to, again, reduce the ability for recidivism. And then the big one, I would argue, is trying to get inmates closer to home.
And that's something that I think a lot of people don't know about, I think, but it's really something that we deal with quite a bit. And when someone is convicted of either a federal or even a state crime, a felony where they would be incarcerated, it's important for family members, and it's also important for that inmate to be close to home. There's studies that show that the closer that you are to your family, to where you grew up, or so on and so forth, those things help reduce recidivism and help that inmate or that person when they get out have a better chance on the outside. It is really a really important thing, so we're glad that it's cleaned up.
Right. I mean, especially because, Bureau of Prisons, Department of Corrections for the state of North Carolina, they're some of the only governmental agencies that when they read an order or judgment from a judge can basically say, well, that's a great suggestion, but ultimately we can do what we want. And that's just not something that normally happens. And, just people don't think about it. If you've got a loved one that is even in prison in the state of North Carolina,
Right.
the Department of Corrections for North Carolina can put you anywhere in the state that they deem fit. And there's still a mechanism with the First Step Act from a federal perspective to do that if, it's necessary for safety or for some sort of wellness issue, to go beyond that. But there is a strong presumption that someone should be within 500 miles of where they live so that there's more of a likelihood that you can have those family members come in. I know that in North Carolina, the big federal facility is out in Butner, and sometimes it's hard for people to be able to go there because it's a medical facility. And so there's a presumption that if there's a medical issue, whether it's mental health or physical health, those people need to be addressed with that because it's one of 6 of those types of facilities in the nation.
If you're just joining us on WTOB, for the record, we are talking about the First Step Act, both at the federal and state level. And Dylan, one of the things that we were talking about earlier was reentry programs and how when people get out of prison, what we do to take care of them. And so one of the things this First Step Act does is adds money and incentives to residential reentry programs. And those are really, really important because, there is a transitional period for people between when they get out of federal custody and their reentry into, regular civilian life. And it can be very complicated. And for a lot of people, it helps reduce recidivism. It also costs less for taxpayers to have home confinement or halfway house confinement. And these programs are really, really vital into ensuring that that said person doesn't commit another crime and go right back into federal custody. And a lot of times, people are on post-release supervision, and there's some other things involved where, if they do reoffend, they could be right back into federal custody. So it's important to have this transitional time. And in addition to that, on the First Step Act through money, millions of dollars at rehabilitative programs. And this is also important, sort of goes along with reentry programs, because part of the goal of incarceration is to rehabilitate. And again, we understand that there's a punishment aspect to this, and people are being punished for committing a crime, but it's also important as a society for us to rehabilitate these people so that they can come back into society and be functional. And so what this does is it takes medium and high risk prisoners and gives them a priority for placement and rehabilitative programs. And part of the way it does that is giving some incentives to prisoners to be a part of these programs. So giving them more phone time, more money on their commissary, stuff like that, that gives them a reason to want to do these sort of rehabilitative programs, and thus, when they get out, they are in a better position to be productive members of society. So,
and one of the big things that it can contribute to is more time credit. Now, it's not time credit in the sense of what we talked about before, where you get days off of your sentence. It's time credit in the sense that you're getting more days in those residential reentry programs. So it's a sliding scale that's moved from, well, all of a sudden, let's say you got 10 years in a federal prison and you had the ability to get out for a residential reentry program after 9 of those years. If you do enough of these types of programs, you could actually work that time to where maybe you get in one of those residential programs at 7, 8 years instead of at 9.
Right.
And so you get there sooner, you get to try to re-enter society sooner, you take some of the pressure off of some of the prison overcrowding that we have. All of that type stuff can really be great, because that way you're putting people in a situation where they can have educational opportunities, they can have vocational opportunities, skill opportunities to be able to come out and do something productive and try to re-enter society.
And so we've talked about how the First Step Act, from a federal perspective, is pretty broad, deals with, a myriad of different issues. But North Carolina also had a First Step Act as well. Can you explain some of that?
So the First Step Act in North Carolina, while it shares the same name as the federal First Step Act, is a shell of what that act does. Now, the federal one benefits from the fact that you have federal money backing it up.
Right.
It's a lot of money. The state one, not so much. Although the state of North Carolina spends a lot of money on prisons each year, because at any given time it incarcerates anywhere from 35 to 40,000 people in its prison system at a given moment. And so the First Step Act created a specific, and when I say specific, I mean very specific, safety valve for certain first-time drug trafficking offenders to be able to fall, for their prison sentence to fall below the mandatory minimum of what they would have been facing.
And can you explain? I know that we talked about some of the how narrow this is.
So I think by our calculation, I think maybe 3 people in the whole state of North Carolina might qualify. I mean, it's that narrow. That's a bit of a hyperbole, but still, you have to meet 11 factors. And if you don't hit any one of these factors, you don't get this benefit of this law. So first and foremost, you have to have the lowest level trafficking offense that you can get. And so for any specific type of substance, there's a low level offense, a medium level offense, and a high level offense. And it's all based off of the weight of the substance that's being looked at, typically. And so the weight can go up pretty drastically, pretty easily, because of the rules pertaining to what constitutes a mixture.
Right.
So if that drug is mixed with anything and there's a trace of that drug within that mixture, the whole mixture gets weighed, not just the drug if they were able to pull it out of the mixture. So all of a sudden, weights get out of control pretty quickly. What a lot of people also don't realize is that it's very easy to have a trafficking amount of substance, especially for like a prescription drug.
And that's what we see the most. I mean,
yes,
people, when we talk about trafficking, the initial concept people have, and a lot of people even charged with trafficking, is that, it's somebody, being a mule from New York to Georgia sort of type thing. That's not typically what we see. Normally, trafficking, people that are charged with it, it's simply a possession of a controlled substance and it's possession of a certain amount of a controlled substance knowingly. And sometimes, a lot of times, that happens in a vehicle and they're stopped.
Right.
And they possess some amount of this.
Right. I mean, for instance, and I think probably what this this act was thinking about in regards to drugs was the person who maybe they had never been a user before, maybe they had a surgery or something, were prescribed an opiate during surgery, they got hooked on that opiate, maybe they tried to find more, maybe they bought somebody else's prescription bottle. Well, a whole prescription bottle, depending upon what schedule it is a trafficking amount of that substance. And they would never have thought that. But it certainly can be. And then all of a sudden they're charged with drug trafficking and facing anywhere from a 25-month mandatory sentence all the way up to what we were talking about before with the 18 years plus. And so that becomes a big issue. So you have to have that lowest level, that 25-month level of drug trafficking. And then there's 11 factors, and so we're going to run through those. The first is that the defendant has to accept responsibility for the crime, just in its entirety. And in addition to that, you cannot have a prior felony drug conviction under North Carolina Statute 90-95. 90-95 is the drug statute in North Carolina. It sets out all the schedules and all the punishments and all that stuff. The third thing is that you did not use violence, a threat of violence, or possess a firearm or other type of weapon in the commission of the offense that you're currently being sentenced for. And then you also can't have committed violence, a threat of violence, or possessed a firearm or another weapon in the commission of any other crime, no matter what the crime was that was committed. So you can't have any prior history of any type
no matter when it
was.
So it could be 20 years ago, you had a, carrying concealed gun, then you're out.
And then, you no longer get this benefit. And so then you have to also admit that you have a substance abuse disorder and that you have successfully completed a court-approved drug program. Harold, how many people that are charged with drug trafficking get out on bond?
Not as many as they should.
Not too many.
No.
And so then all of a sudden you get in a situation where very few people get out on bond to be able to do these types of programs.
Because these bonds can be really high.
Right. And so the ability to actually get in there and do something like that, while beneficial to that person and would likely help that person a great deal, is very hard to achieve. And then a court also has to make a finding of fact that imposing a mandatory minimum sentence would result in a substantial injustice.
And I can see all sorts of arguments being made in court about that.
Yeah, because every single one of these factors goes before a specific hearing where the state of North Carolina gets to put up all kinds of evidence in regards to your case. They get to call the officers involved.
There's no hearsay involved?
No, none of that stuff. Anything is up for grabs in it. And so then there also has to be a finding of fact that the mandatory minimum sentence is not necessary for the safety of the public, and that the defendant is sentenced only for the result of possession of the drug. Now, drug trafficking can be a lot of other things besides possession.
It can be manufacturing, it can be distributing, it can be numerous other things, but possession is just one of the ways that you can potentially be convicted of drug trafficking. So there are numerous different ways that you can.
And there has to be substantial evidence. There's no substantial evidence that the defendant has ever at any time engaged in the sale, manufacture, delivery, or transportation of a controlled substance. That's pretty narrow in regards to these cases, because almost every single drug trafficking case we come across involves a car. I mean, there's very few that are out of somebody's house. And so all of a sudden you're transporting that drug by it being in the car. And then the defendant, to the best of their knowledge, has provided all reasonable assistance in the identification, arrest, or conviction of any accomplices, co-conspirators, accessories, or principals. And then the last one is that the defendant is being sentenced for trafficking for possession, and that the drug amount is within the lowest category itself. As you can see, all these factors combined, it's a very narrow group of people who could even qualify. It's a good step in the right direction.
It is.
Considering how stringent these drug trafficking penalties are. In fact, North Carolina's are so strict that a lot of times the feds decline to prosecute somebody because they know that they're going to get more time in the North Carolina prison system. Isn't that right here?
And that's different than some of the surrounding states that have since modified some of these mandatory minimums for all the reasons that we talked about earlier. But North Carolina, I mean, even though this is a step in the right direction, has been slow to modify these things.
And there is a provision in the statute that does allow, if you feel like you or a loved one might have qualified for this, maybe they're still in prison, and there is an ability to do what's called a motion for appropriate relief to try to undo the sentence and try to institute the safety valve. But again, you've got to qualify for all those factors. But again, it's very narrow, and it's a step in the right direction, but it's really hard to qualify. Everybody, thanks for joining us here today on For the Record with Greenwood Law to talk about the First Step Act from a federal perspective and from a state perspective. Hopefully we were able to shed some light on a big issue that is facing our society that sometimes is easy to kind of push back in the recesses of your mind, not necessarily think about. But next week, we're going to switch gears a little bit, and we're going to talk about child support and how child support in North Carolina is calculated, how it's modified, and some of the issues surrounding child support, because it's a big deal, especially with how COVID has impacted people and their jobs and their ability to bring money home. So tune in next week to learn all about that as it relates to North Carolina.
Before we go, though, don't forget the Greenwood Law Bill of Rights. First, I will not represent myself in court. 2, I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. 4, I will not consent to searches when asked by law enforcement. And 5, I will not be my own star witness for the prosecution. Remember, everyone, that it's not a crime to know your rights. Stay informed, stay safe. This is Greenwood Law, For the Record, signing off.